Hello and welcome to Course 7 of the Monique and Roland Vale People's Academy International Law. My name is Gail Davidson. I'm a member of the People's Academy Task Force, filling in for Dean Marjorie Cohen. Our topic today is the international law of armed conflict and challenges to its enforcement. This course will cover the legal principles and provisions of the law of armed conflict, the criminalization of violations, command responsibility, and international accountability, with a particular focus on Gaza and Palestine. When states are engaged in armed conflict, there are two different legal questions or issues to examine. The first one, is the use of force lawful because it is being conducted in self-defense, or does it constitute illegal aggression under the United Nations Charter? That is called jus ad bellum and is analyzed using the principles of international human rights law. The second question or issue to be examined is whether the force is lawful or unlawful. What are the limitations on that force? And that is called jus in bello, the international law of armed conflict, sometimes called international humanitarian law. And even if the use of force is illegal, all parties to the conflict must abide by international law of armed conflict. Now, these laws grew out of an attempt by states to not prohibit war, but to make war less devastating for combatants and non-combatants. This body of law is codified in the Hague and Geneva Conventions and their additional protocols. The provisions require states to engaged in combat to make a distinction between combatants, armies, tanks, and military equipment on the one hand, and combatants, non-combatants, civilians, and civilian objects, residences, schools, hospitals, and other facilities on the other hand. The law prohibits the targeting of civilian and civilian objects. Weapons that do not discriminate between combatants and civilians are generally prohibited, and notice of planned attacks must be given to enable non-combatants to escape. The law requires proportionality, allows only the amount of force necessary to achieve a legitimate military objective, and seeks to prohibit attacks that cause disproportionate harms to civilians. Our faculty for this course are Raiss-Toussi, Chantal Meloni, and Katherine Gallagher. Each of these very learned presenters will speak for 40 minutes, and then for approximately 15 minutes, they will comment on each other's presentations. That will be followed by a question and answer period, so please put your questions in the question and answer box. We have French, Spanish, and English translation. Videos of the presentations in English, French, and Spanish will be posted on the peoplesacademy.net website. I'd like now to introduce you to our faculty members. Raiss-Toussi is a senior lecturer and director of the master's program in international law at Anglia Ruskin University in London and an associate professor at Birkbeck University. Ali has taught courses in several areas of international law, including public international law, the law of armed conflict, human rights law, and international space law and policy. His conference presentations include Just War and Wars of Aggression in the Abrahamic Faiths, Victor's Justice, Reassessing the Tokyo and Nuremberg Crimes Tribunals, War Crimes Tribunals, and Teaching Public Law as an Act of Dissent. Ali is a fellow of the UK Higher Education Academy and a member of the British Interplanetary Society. Raiss-Toussi will explain the rules of the law of armed conflict with reference to the Hague and Geneva Conventions. The second faculty that you will hear from today is Chantal Meloni, who is a criminal lawyer an associate professor of international law at the University of Milan, senior legal advisor on international crimes and accountability for the European Center for Constitutional and Human Rights. Chantal is on the list of assistant counsels for the International Criminal Court, where she represents Gaza and Palestinian victims. Chantal has a PhD with a thesis on command responsibility. She was a member of the commission that drafted the project for an Italian Code of International Crimes. Chantal has been an expert in roundtables organized by the United Nations and by the European Union Parliament. She is the author of numerous articles and book chapters. She is the co-editor of Domesticating International Criminal Justice and Is There a Court for Gaza? Chantal has spent several months in Gaza, where she collaborated with the Palestinian Center for Human Rights. Chantal Meloni's presentation will focus on the criminalization of violation of the laws of armed conflict, command responsibility, and accountability for violators. And lastly, today you will be hearing from Katherine Gallagher, who is a senior staff counsel for the Center for Constitutional Rights in New York, where Katherine works on holding U.S. and foreign officials, as well as corporations, accountable for serious human rights and international law violations. Katherine has represented victims and survivors of war crimes, crimes against humanity, and genocide in many courts: U.S. federal court, non-U.S. national courts under the principle of universal jurisdictions, UN treaty bodies, and at the International Criminal Court, where she currently represents Palestinian victims in the ongoing International Criminal Court investigations, including investigations into the current genocide. Prior to joining the Center for Constitutional Rights, Katherine worked at the International Criminal Tribunal for the former Yugoslavia from 2001 to 2006. Katherine Gallagher will analyze Israel's violations of the laws of armed conflict in Palestine. And now I give the floor to Professor Ali Raiss-Toussi to tell us about the Geneva and the Hague Conventions. You have the floor, Ali. Thank you.
Thank you very much, and good day, everybody, wherever on God's earth you are. So the good day will cover the good morning and noon and afternoon and evening. I have prepared some slides which I would like to share. So I'm not sure whether I can share them myself or whether I should ask Erin. Let's see if it works if I share them. So apparently it does work. There are two views on war: the view of the general and the view of the lawyer. You can see them here, completely different, but still very relevant today. Admiral Lord Fisher, who was commander of the British Royal Navy in the distant past, has said that if he were to be in command if war breaks out, his first order would be: the essence of war is violence. Moderation in war, according to him, is imbecility. Hit first, hit hard, and hit everywhere. It is perhaps because of views like this that it is said that war is too serious and too important to be left in the hands of the generals. Let's compare what he said to Professor Solis, who is or was before retirement a practicing lawyer and also taught at the US Military Academy. The idea of war as indiscriminate violence would suggest that violence is an end in itself. But this is in clear conflict to the facts that war is an activity that is clearly goal-oriented. You have political objectives that you cannot attain through other means, therefore you resort to war to attain those means, and once you have attained your goal, then everything is over. So war within a legal framework, not all-out violence because you are the stronger party and able to get away with it. As I said, still very relevant today, because even though law is meant to create this legal framework, in the vast majority of cases, it has not succeeded. For the non-lawyers in the audience, very quickly, when we discuss the laws of war, as Gail said earlier, there are the two strands. The jus ad bellum, which is the right to wage war. Under which circumstances can a state resort to force? The answer in international law today, post-Second World War, is very clear. The answer, as the Charter of the United Nations tells us, is there can be no use of force at all whatsoever unless you have been attacked and you are defending your own territory, your own country, your own people, or the UN Security Council authorizes the state to enter into war. For example, when Iraq invaded Kuwait back in the early 1990s, Kuwait was unable to defend itself. The UN Security Council called for an international coalition to enter into a war to remove Iraqi troops from Kuwaiti territory. Only these two circumstances. Other than this, there is no right to wage war. The second strand, the jus in bello, if war is being waged, in what manner should it be waged? What things can be legally done and what things are unlawful? What weapons can you use? In what way can you use them? Can you target civilians, or is there an absolute ban on civilians being targeted or civilians dying because they happen to be in a place where the military target was situated? All of these issues are discussed in jus in bello, which is the strand that we are going to be talking about today. Now, sometimes war and armed conflict are used interchangeably, but that doesn't mean that they have the same meaning. There's a slight nuance between the term war and the term armed conflict. An armed conflict is understood to be broader than war. When the four Geneva Conventions of 1949, and we'll come to the Geneva Conventions in a moment, were negotiated and agreed, the state parties intentionally moved away from using the terminology of war to the terminology of armed conflict, because war takes place and happens when states agree or admit or issue a declaration formally saying that they are at war. However, a state may attack another weaker state, might commit aggression against another weaker state without formally recognizing the situation as a war, without formally accepting and declaring that they are at war. In these circumstances, the attacking state would say, these rules do not apply because we are not at war. However, the move from war to the term armed conflict means even if one of the two parties or both of the parties refuse to accept that the state of war exists between them, there are clearly hostilities taking place with the use of weapons. And because there are armed hostilities, therefore, the rules of jus in bello, whether they are in the Geneva Conventions or in earlier Hague Conventions or in other treaties signed after the Geneva Conventions dealing with specific issues, they will all apply. So we have to be aware of the terminology and the nuances between the different words. The law of armed conflict applies both in international armed conflicts, where states are fighting each other, and also in non-international armed conflict, where the fighting is limited to the geographic confines of the territory of a single state, where, for example, you have a separatist movement fighting the central government, or you have different separatist movements, different ethnic groups fighting each other, whether or not the government is siding with one or the other. The protections in international law are much better for international armed conflicts than non-international armed conflicts. And the reason is, in a non-international situation where the conflict happens within the territory of a single state, states would say it is a domestic affair under their own jurisdiction where they have full sovereign rights. They are not willing to agree and accept to limitations on their sovereign powers in the same manner that they would be when it comes to international armed conflict. And it is because of this that the protections in non-international conflict are far, far weaker, unfortunately. Right. In terms of the rules that exist, there are two strands of rules and two strands of law that are generally known as Hague law and Geneva law. When we talk about Hague law, we are referring to the various treaties agreed, negotiated, agreed, and signed in The Hague, originally in 1899, and then later on in 1907. And these treaties regulate the conduct of hostilities. That means they regulate what the armed forces of State A and State B can do or cannot do when they are confronting each other, what weapons they can legitimately use or what weapons they can't. So Hague law, in a kind of imprecise division of the two strands, deals with the rules around how you conduct your warfare. Geneva law, however, today is based upon the 4 Geneva Conventions negotiated, agreed, and signed in the immediate aftermath of World War II in 1949, but they have a history longer than that. And Geneva law does not deal with regulating the conduct of hostilities. It deals with the rights of people who are not in combat. Soldiers on the battlefield who have been injured and wounded, they can no longer bear arms, they cannot pick up their weapon, they need a degree of protections. Prisoners of war, they are no longer in combat. They are not fighting. They've been taken by the enemy. They have certain rights. Geneva law deals with the rights of prisoners of war. If State A attacks State B, occupies all or part of the territory of State B, the civilians living in the occupied territory will have rights. rights that the occupying power, the occupying state, has an obligation to consider and to look out for. And Geneva law deals with these issues, the rights of people who are not in combat. Hague law and Geneva law was, to an extent, merged together in 1977 when two protocols were added on to the four Geneva Conventions. A protocol is an extension of a treaty that usually is negotiated and agreed after the original treaty has been signed and has come into effect. So it is an afterthought when states later on agree to other things. The four Geneva Conventions have three additional protocols. The first two were agreed and opened for signature in 1977, and they are important. Specifically, additional protocol number 1, which covers both the rules regarding means of warfare and methods of warfare, i.e. Hague law, and the rules on the protection of civilians, which would have been Geneva law. However, we have to be aware that the two additional protocols of 1977 are not universal, unlike the Geneva Conventions. When we say the Geneva Conventions are universal, it means that every state on planet Earth has agreed and has accepted obligations under those treaties. There is no state that formally says, I do not accept and I refuse to follow the obligations in these treaties. They are universal. The additional protocols, however, are not universal. There are several states, and I call them the rogue states, that have refused to sign on and therefore are not bound by the extra restrictions that the additional protocols impose. Looking at the Hague Conventions, originally 1899, I said a little bit earlier, there were three treaties signed. In 1907, 44 states sent representatives to the Netherlands again. They revised the original three and they adopted several more treaties. So this slide and the following two explain at least what each of these treaties is about. The most important is Hague number 4, the one that we have in bold here. And Treaty number 4 from 1907 is on the laws and customs of war on land. So it deals, for example, on combatant status. Who is a combatant? If you want to benefit from the rules within the treaty, and you want to benefit from the rights that the treaty provides, then you have to meet the definition of who is a combatant, who is a belligerent. And the treaty says, anyone who is commanded by a person responsible for subordinates. So there must be a chain of command in an army. If there is not a proper chain of command, you will not be protected by the rules of the treaty. You must have a uniform or a fixed and distinctive emblem on you that is recognizable at a distance. Why? Because if you cannot be identified from ordinary civilians, the enemy, the opposition, would not know whether you are a civilian or whether you are a combatant, a belligerent who can be legitimately targeted. So if you're a soldier, and therefore a legitimate target for the enemy, this has to be made clear through your wearing a uniform or a fixed and distinct emblem recognizable from a distance. You must carry your arms openly. If you do not carry arms openly in order to masquerade as a civilian until you're very close to the enemy post, and then bring out your arms to catch enemy soldiers unawares. In these circumstances, the Hague Conventions say you will not be recognized as a belligerent, and none of the rights that the treaty has for belligerents will operate with respect to you. So the Hague Conventions were the first attempt at codifying the law that existed as customary practice before 1889 and 1907. Moving on. Historically, the first Geneva Convention was negotiated and agreed in 1864. It dealt only with injured people on the battlefield. This treaty was revised in 1906. A protocol, an additional add-on, was negotiated after the end of the First World War, prohibiting the use of poisonous gases and also prohibiting bacteriological warfare. In 1929, the 1926 treaty was updated. Other provisions were added to it. The red crescent symbol and the red lion and sun symbol were added to the Red Cross in order to identify societies in Muslim countries that were using the red or wanted to use the Red Crescent, or in the what was then Imperial Persia or Imperial Iran that chose to use the red lion and sun. So the use of those was formalized in 1929. In 1929, a second Geneva Convention, a second treaty, was also agreed dealing with prisoners of war. And this took us to the Second World War. Protections were not good. There was mistreatment of prisoners of war on all sides. There was mistreatment of soldiers who were injured, wounded on the battlefield, at sea, on all sides. And therefore, post-World War II, in the immediate aftermath of the end of the war, representatives of states decided to strengthen protections. And in 1949, the Geneva Conventions that we talk about today, the 4 conventions were agreed as follows. Geneva Convention number 1, following the original 1864 convention as it was updated, deals with the wounded and sick in armed forces on the field. Geneva Convention number 2, as it stands, deals with the sick and shipwrecked members of armed forces at sea. The third one deals with treatment of prisoners of war. It has taken the 1929 treaty on the same subject and added a lot of detail to it, replacing the old one. So, for example, it deals with whether and in what circumstances prisoners of war can be forced to work or not, financial resources available to prisoners of war, relief that they can receive from family members sending them food packages or clothing packages, books, etc. And also judicial proceedings that can potentially be instituted against prisoners of war if they carry out criminal acts while they are being held by the enemy. Geneva Convention 3 says, for example, all POWs have a right to humane treatment. There can be no physical mutilation. They cannot be used as guinea pigs for medical experiments or scientific experiments. Their organs cannot be removed for transplantation. They cannot be subject to prolonged questioning. They cannot be given inadequate food or inadequate quarters or inadequate clothing. No degrading or humiliating labor, even though they can be required to work. The country holding POWs cannot insult the prisoner in person, his country's flag, his religion, his beliefs, etc. And there are several other rules around the rights of prisoners of war, all within Geneva Convention number 3, which I don't think that I have the time to go into more details. Geneva Convention number 4 finally deals with protection of civilians, mostly in terms of civilians who are living under occupation. It creates and defines obligations for the occupying power. It includes provisions on humanitarian relief for populations that live under occupation. So the law is clear that the civilian population of an occupied territory have no allegiance to the occupying power. Therefore, they can't be forced to be involved with the occupiers or give military assistance to the occupiers. At all times, they're entitled to respect for their person, for their honor, for their family rights, for their religious convictions, for their own manners and customs, and their private property rights are also protected. The occupying power must guarantee that the occupied territory is provided with foodstuffs and medical supplies, as well as sufficient clothing, bedding, and means of shelter for the people living under occupation. So these are all examples of rights of civilians living under occupation. There can be no collective penalties. There can be no forcible transfer or deportation of civilians from occupied territories. There can be temporary evacuations, temporary only, if warranted by the security of the population, only, the law says, if proper accommodation is provided for the evacuees, if the evacuation is carried out in satisfactory conditions of hygiene, health, and nutrition, and family members are not separated. More importantly, the occupying power cannot transfer parts of its own civilian population into the territory that it occupies with an eye on annexing it in future. But this principle has been violated and continues to be violated. One example of violation we see today, the terrorist state of Israel and the occupation of Palestinian territories on the West Bank, and also Morocco, its occupation of the Western Sahara, moving its own civilian population into the Western Sahara with impunity in order to justify title for the Western Sahara that Morocco does not have. Right, moving on. The 4 Geneva Conventions of 1949 have a number of articles in common. So although they deal with 4 completely separate issues, they have articles that are exactly the same across all 4. They are known as the common articles. Common Article 3 is very important in this regard. It extends the protections that exist in international armed conflict to non-international conflicts. So protections that exist when countries A and B or A, B, C, D, etc., are fighting each other. It extends those to circumstances where a government is fighting a group of its own population. They might be separatists based on ethnicity. They might be a separatist movement based on a certain part of territory, or for any other reason. In these circumstances, governments cannot claim that because everything that happens within their own national jurisdiction, within their own territory, international law does not apply. National laws apply only because Common Article 3 extends some of those protections. So, humane treatment for all persons in enemy control. Enemy control means if you're fighting for the state, you've been taken by the rebels. If you're fighting for the rebels, you've been taken by the state. Your captives cannot be murdered. They can't be mutilated or tortured. They cannot be subject to any form of humiliating or degrading treatment. One of the parties, whether the state or the rebels, cannot take hostages in order to advance their aims. The state cannot rely on unfair trials to crush a rebellion. Common Article 3 is important today because most of the armed conflicts are non-international. If we look at civil war in Sudan, we have one example of a non-international armed conflict. If we look at what was initially civil war in Syria, it was an example of a non-international armed conflict, which later on became internationalized, but that's a different story for another day. I've briefly mentioned the 2 additional protocols to the Geneva Conventions that were negotiated and agreed in 1977. The first deals with international armed conflict, the second one with non-international armed conflict. Additional protocol number 1 deals in part with people fighting against colonial domination, extends rights to national liberation movements who want to end colonial domination, whether it's British colonialism, French colonialism, Spanish in the Western Sahara, Portuguese, etc., etc. National liberation movements fighting alien occupation, fighting Israeli occupation or Moroccan occupation, or fighting racist regimes. South Africa before the 1994 elections under apartheid, or the situation in Israel-occupied Palestine today. It adds protections for national liberation movements. It allows combatant status and prisoner of war status for peoples who are fighting to free their countries. The problem is that the additional protocols do not have universal acceptance. Additional protocol 1 has 174 states that are parties to it have accepted the treaty, and the additional protocol number 2, 168 states only. Given that there are roughly 197 states on Earth, we have a large number who have refused to accept the rights and the necessary obligations that go with those rights. And the states that refuse to accept are usually the states, I call them the rogue states, that violate international law. Examples here on the slide: United States, the government of Israel, the governments of Turkey and Myanmar. They're examples of states who have refused to accept the additional protocols, which tend to tie their hands behind their backs somewhat. I don't know how much time I have left. but I will try to wrap up, and there are not many slides left now. So Gail did mention at the very start and the introduction that the law of armed conflict is based on some fundamental principles. So the principle of distinction. If you're fighting a war, you have to distinguish between the civilian population and between combatants. Combatants can be legitimately targeted. Civilians cannot be targeted. The principle of discrimination, which bans indiscriminate attacks. You cannot carpet bomb a whole city or an area of a city in order to destroy a military target that happens to be situated in that area. The principle of military necessity. Only take measures that will weaken the enemy to the extent that will achieve the enemy's surrender, which is the ultimate political goal that, if we remember the quote from Gary Solis, Professor Solis, on the very first slide, is what states want. If you cannot achieve your aims through peaceful means, and therefore you resort to non-peaceful means, you resort to armed conflict, what you want, your ultimate aim, isn't violence and destruction for the sake of violence and destruction. You want the enemy to surrender. You want the enemy to accept your terms. So you will adopt measures that will achieve your aim, getting your enemy to surrender. You are capable of more violence, but the law of armed conflict says you cannot lawfully adopt stronger and harder and harsher actions. The principle of proportionality. You want to carry out an operation. In this operation, you might be able to target enemy combatants, but there might also be so-called collateral damage. Damage to a museum. Civilians may die. Damage to a school, damage to a hospital, damage to civilian infrastructure. The principle of proportionality says if your operation, if your attack is going to have collateral damage, you must be able to ensure before the attack that the military advantages that you gain outweigh damage to civilians. You cannot justify 100 civilian deaths in order to kill one soldier. But if you are targeting a military barracks where there are several hundred soldiers, and as a result of your operation targeting the barracks, a civilian may have been in the vicinity who is injured or who dies, the law of armed conflict allows it. Human rights law might have a different view, but the law of armed conflict allows it because it is, according to the law of armed conflict, proportional. So the principle of proportionality is important in this regard. And prohibition on causing unnecessary suffering and superfluous injury. What does this mean? It means limits on what means you can use and what methods you can use in your armed conflict. So, chemical weapons. The Hague Law from 1907 says no poison gases. More recently, 1993, the Chemical Weapons Convention, a treaty banning chemical weapons. Why? They cause unnecessary suffering and injury. The Biological Convention from 1972 is another example. There are other prohibited weapons, weapons that will fragment inside the body and leave fragments that can't be detected by X-rays. If an X-ray cannot detect part of a bullet inside somebody's body because the bullet has glass, for example, or plastic parts that can't be caught and seen by an X-ray, there can be no successful operation to take it out. The soldier will ultimately suffer and then unnecessarily die. So this is a whole new and complex aspect of the law, which would need a separate study and a separate discussion. But it is sufficient to say that any means or method that causes unnecessary suffering or superfluous injury is unlawful, except perhaps when it comes to use of nuclear weapons. And you might think that, well, use of nuclear weapons is by far the greatest example of a weapon that causes unnecessary suffering and superfluous injury. It is clearly disproportionate because a nuclear weapon does not consider any difference between military and civilian. It doesn't distinguish. It is indiscriminate. But when the International Court of Justice was asked in 1996 to provide an advisory opinion to the General Assembly of the United Nations on the legality of the use of nuclear weapons, the decision of the court was that we cannot clearly prohibit the use of nuclear weapons. The advisory opinion said that use of such weapons could be permissible in extreme cases of self-defense. A country is under attack. It is facing annihilation, being completely wiped out by the enemy. Conventional weapons are no good to stop the enemy's onslaught. Therefore, as a last resort, they would want to use nuclear weapons. And the judges sitting on the court said, we can't say specifically that in these circumstances, use of nuclear weapons would be unlawful. Of course, there has been severe criticism of the ruling, but that is where the law stands today. So to wrap up, although the Geneva Conventions confer universal jurisdiction, they have been accepted by all states, all governments on earth. If the Geneva Conventions are breached, there is no guarantee that the party that has breached them will go on trial. Colleagues will discuss this, so I do not need to get into this much further. But the reality is that when it comes to the structures available in international law to deal with violations, those structures are very weak. We have a number of ad hoc, temporary courts and tribunals. For example, the International Criminal Tribunal set up for the former Yugoslavia or set up for Rwanda. We also have a permanent International Criminal Court with jurisdiction over war crimes, in addition to other crimes. But the ICC itself, over the past 20 plus years, has shown itself to be, to put it diplomatically, less than competent. So the rules are there, the rules exist. However, the rules, unfortunately, are broken by states that are powerful enough and strong enough to break them. And once they are broken, there is no real judicial process to bring culprits to account. Thank you very much.
Thank you very much, Ali Raiss-Toussi, for explaining so well the Hague complexities of the development of the Hague and Geneva Conventions, to the post-war developments of the protocols that expanded the substantive protections for non-combatants and expanded the restrictions on on use of force in both national and international and non-international conflicts, and also bringing us into realization of the lack of implementation and enforcement of these measures. Thank you very much. I would like next to give the floor to Chantal Meloni, who will be talking about, following up on these comments by talking about the criminalization of violations of the laws of armed conflict, command responsibility, and accountability for violations. So Chantal, thank you very much.
Thank you, Gail, very much for inviting me today. I'm very glad to be here and to have the opportunity to go deeper into this fundamental topic that unfortunately we see every day now in these horrible years and months, becoming more and more relevant for us as lawyers, as people of conscience, and of course for our advocacy in many situations, and in particular, as you mentioned, in the situation Palestine. So let me try to share the screen. So can you see it? Can you just confirm that you see the presentation?
Yes.
Okay, thank you. So, of course, I had included some slides that in part overlap with what was the presentation before me, and therefore, don't worry, I will skip them and go quickly, passing to the next one. But because as it was introduced, I am going to talk about the next level, which would be the criminalization of the provisions regarding violations of international humanitarian law. Of course, my starting point is also international humanitarian law, and in particular, of course, the Geneva Conventions and the associated regime. And I had started with a slide that I normally use also with my students in the university. Sometimes it's nice to give a face to some people that have left such a huge legacy for us in our world. And this is Henry Dunant, that you probably already heard of, the Swiss businessman who, after the Battle of Solferino, where he had the chance to see the horrors of what was left on the field in that battle in the 19th century, and he was so shocked that then started to work in order to create a relief organization that was thought in reality for the wounded and sick on the field, so the soldiers, but then developed to be the International Committee of the Red Cross. And he was the recipient of the very first Nobel Prize in 1901. So from then, of course, a lot of development happened, which were already brilliantly told you by Ali before me. And so this development of international humanitarian law along the two lines that were already described, Geneva and The Hague, it's clear we don't need to go again through these. But what I want to highlight is that there is still a very, very strong tension between the two main components of this field, this branch of international law. On the one side, the military goals of the war in itself, and on the other side, the humanitarian considerations. And so this branch of international law is really very complicated, especially today, in front of the basic principles that we also have already heard of, to be applied in the context of our contemporary conflicts, asymmetrical conflicts, where very often it's not even clear whether there is a state of war, and it has been blurred, the very confined, the very border between what is a situation of war, which already started, and the waging of the war, where in international law you have different legal regimes applying to the one and the other. And in the one case, the criminalization of international humanitarian law is the war crimes regime, and in the other case is the crime of aggression. So for my presentation of today for you, I will only focus on the war crimes regime, so the criminalization of international humanitarian law. And here again, we go to the Geneva Conventions that were already, introduced by Ali. And in particular, we focus on one specific aspect of the Geneva Conventions, which is the grave breaches. So as you have heard, in each and every Geneva Convention of 1949, there is one provision that criminalizes particular violations of the Geneva Convention itself, the specific one, as grave breaches. And for each of the Geneva Conventions, the article which criminalizes these violations has a different number. In the first one is Article 50, as you can see in this slide, I just summed it up. The Geneva Convention second is Article 51. For Geneva Convention 3 is Article 130. For Geneva Convention 4 is 147. And in the Geneva Convention 4 is, and for additional protocol 1 is Article 85. We don't have any provision regarding the grave breaches in our additional protocol 2, because at the time when it was drafted, the idea was still that the grave breaches regime had to do with international armed conflicts, and there was just one provision that is common Article 3 in the Geneva Conventions regarding non-international armed conflicts. So what does it mean that we have this kind of regime, the grave breaches regime? It means that certain violations, because they are particularly grave, require states to adopt, to take appropriate action under domestic law. In particular, states are obliged, according to these provisions, which are identical, even if the numbers change in the 4 conventions and in the additional protocol, they are obliged to undertake to enact any legislation necessary to provide effective sanctions, criminal sanctions, for those who commit, order, or participate in any of the grave breaches of the convention. And moreover, each high contracting party, meaning each state, shall be under the obligation to search for those who are alleged to have committed, or again have ordered to be committed, such grave breaches, and shall bring such persons, and this is very important, regardless of their regardless of their nationality, before its own courts. So there is also an alternative if the state is required to extradite these suspects which are found on its territory. It may also do so, if you see the language, if it prefers. So there is an obligation that in Latin is expressed traditionally as the obligation of aut dedere, aut judicare, meaning states have an alternative, which is either they proceed with regard to the suspects of the commission of grave breaches, meaning war crimes, before their own courts, or they extradite the suspect to another state which possibly asked for this, for this extradition. So what is clear is that states don't have the opportunity just to stay put and do not do anything. So this is not something that states can do in front of the Commission of War Crimes. They have to undertake action. In the first place, provide for the criminalization of these conducts in their own domestic legislation, and second, enact, so enforce the legislation when a suspect of these violations, of these crimes, is found on their territory. And by the way, there is also, as we said, an obligation to search for these suspects. So these Geneva Conventions of 1949 are the first treaties that require such criminalization of certain violations of international humanitarian law. And from 1949 till today, this law of war crimes has evolved, and the principle is firmly settled that certain violations of international humanitarian law entail individual criminal responsibility directly under international law. And these are exactly what we call the war crimes in international law, and are under the jurisdiction of international criminal tribunals, but also under the jurisdiction of domestic criminal tribunals. The fact is that sometimes it's not that easy to understand, determine which violations of international humanitarian law create such an individual criminal liability. And indeed, historically, it has been one of the main challenges, and is still in a way one of the challenges faced by judges to understand what provision creates direct criminal liability on individuals in international law. Because this is something that needs to be said and to understood very clearly from the beginning, that international law, and particularly international criminal law, develop, evolve, change. They are subject to a process which brings new war crimes. And one of the things, for instance, that happened is that with regard to certain war crimes that were only relevant if committed in the context of international armed conflicts, now they are also recognized as relevant in non-international armed conflict, meaning internal conflicts, as we were hearing before. Most of the conflicts today is of a non-international nature, and that's why it is so important to recognize which war crimes apply in this context. So just to repeat a concept that I find really crucial to understand for maybe those of you who don't have basic knowledge about this. In international law, we have two different parallel responsibilities On the one hand, there is the responsibility of states that is not criminal, it's a civil liability for the commission of war crimes, grave violations of international humanitarian law. But at the same time, and this is what we are talking about specifically in my presentation, there is a parallel responsibility of individuals. And this parallel responsibility of individuals is of a criminal nature. So we should see international criminal law as an enhanced, a stronger level of protection, and also as an enhanced mean of deterrence. So the violations of international humanitarian law will not only be entailing a responsibility of states, but also will be criminally prosecuted, meaning that the individuals who are responsible for them, and we will talk about this in the second part of my presentation, who are these individuals, can be criminally prosecuted, and of course, upon them, a criminal sanction, in particular, in the form of imprisonment nowadays, can be imposed. So the first example of this, we have it in Nuremberg. As you maybe know, in the Nuremberg Charter, after the Second World War, of course, 1945, there was an article which was criminalizing war crimes, and this was the language that was used at the time. War crimes, violations of the laws of customs of war. And these violations shall include, but not be limited to, murder, ill treatment, deportation, slave labor, or for any purpose of civilian population in or in the occupied territory, murder or ill treatment of prisoners and persons on the sea, killing of hostages, plunder of public or private property, wanton destruction of cities, towns or villages, or devastation that is not justified by military necessity. So we have a sort of catalog, a first catalog of what are the war crimes entailing individual criminal responsibility. And you see it's a bit rough still, the way it is, so to say, codified. It's not a real codification, of course, it's an international instrument. But we have already, in a nutshell, already in 1945, we have, in a nutshell, the concept of what would then become war crimes in a much longer provision that is now included in the Rome Statute of the International Criminal Court. So from Nuremberg, I'm going very fast. Of course, there would be also other steps in between, but we jump passing from the ad hoc tribunals, which I don't mention, we jump to the Article 8 of the Rome Statute of the International Criminal Court. And even if we cannot say that it is an international criminal codification, still, in the Rome Statute, in Article 8, if you take it, you will see it is several pages of listing of war crimes. There is a catalog that is definitely very comprehensive of what nowadays are considered to be war crimes. This doesn't mean that other war crimes might also exist in the development, which of course it's always ongoing under international customary law. But for the purposes of the Rome Statute, which means for the jurisdiction of the International Criminal Court, Article 8 is authoritative. In the first place, the judges will have to apply the statute. In particular, it is said that these war crimes become relevant when they are committed as part of a plan or a policy or as part of a large-scale commission. We don't have the time, of course, we don't want to go into the detail of Article 8, which, as I said, is very, very long. I just mentioned the structure of it, which is quite complicated. The article is divided in two basically main parts. Each of them has two subparagraphs, so there are 4 subparagraphs. The first 2 have to do with international armed conflicts, and the second 2 have to do with non-international armed conflicts, and they in a way mirror each other, but still the structure that is adopted has been adopted in 1998, so quite a long time ago, 25 years ago, by the statute drafters, still has this distinction in the structure, which is on the one hand the grave breaches of the Geneva Conventions for International Armed Conflicts and other serious violations of the law and customs of war, also for international armed conflicts, and on the other hand, the serious violations of Common Article 3 to the Geneva Conventions, which is, as I said, the only provision in the Geneva Conventions regulating non-international armed conflicts, and other serious violations of the laws and customs of war for non-international armed conflicts again. So this is the structure of it. And in this structure, we can identify the elements of what are the war crimes. And I tried here in this slide to summarize what are the common elements of the war crimes. So this is, in a way, an analysis that can apply to each and every war crime that we will after quickly have a look to. So in the first place, to have a war crime in international criminal law, and specifically for the sake of the jurisdiction of the ICC, you need to have a context. And of course, the context is the armed conflict, right? So the armed conflict that can be, as we said, international or also non-international, is what is happening. And in this context, individual acts, so specific violations of international humanitarian law, are committed, the specific war crimes that we are talking about. And they are committed not just during, but with a nexus to the armed conflict. So there is what is called a so-called nexus requirement. And also, of course, these individual war crimes need to be committed with intent and knowledge. So meaning that the person, the soldier, the commander, the general who's committing the crimes must have the mental element. So I skip this because in a way I already said, and also Ali before me already said, that there is this problem about the interpretation of what is international, non-international armed conflict. So my bottom line here is that in the end is not that relevant anymore with regard to the war crimes regime to distinguish between international and non-international armed conflict. Why is not that relevant anymore? In particular, because already 20 years ago, the International Committee of the Red Cross, in a very important study on customary international law, concluded that most of the rules of conduct that apply to international armed conflicts nowadays apply also to non-international armed conflicts under customary law, regardless of what is written in the Geneva Conventions or in other treaties. What does it mean? It means that the violations of these rules customary law rules, by definition, has as a consequence the fact that these are war crimes, also if they are committed in the context of non-international conflict. So regardless of how you would interpret, including judges, for instance, the situation in Gaza, right? The conflict that is considered to be among a state, Israel, and a non-state actor, Hamas. Some would say that it is an international conflict, and I think it's correct because Hamas, of course, is a Palestinian armed group, but the whole conflict is happening in a context of occupation, which triggers the international armed conflict regime, but others would claim that it's not, because Hamas is not a state actor, and therefore, according to different definitions of an international armed conflict, this would not fit into that picture. But again, I repeat, the bottom line is that regardless of these distinctions, war crimes committed in international or non-international conflicts, in the end, nowadays, basically are under customary law the same, in the sense that in both cases, they imply the individual criminal responsibility of those who commit these crimes. That's why, in my opinion, it's much better to distinguish war crimes, not like the Rome Statute does according to international, non-international conflicts, but according to what is the protected value. So there are crimes, war crimes that deal with the protection of persons and property, and crimes that deal with, for instance, the prohibition of certain means of or methods of warfare. And here I just skip these slides, but they are in the presentation, so of course you can go back to them. Here I propose, following also the German distinction on these war crimes, a different categorization. And you see there are crimes that are involving killing the persons or mistreatment, sexual violence, slavery, forced labor, intentional targeting of civilians, of course, but also child soldiers. All these crimes have to do with so crimes against persons, and others that have to do with property. So, for instance, the destruction of civilian property, of buildings or civilian infrastructures, and others that have to do with prohibited methods of warfare. And one of these important war crimes has to do, of course, with something that we are talking a lot in these months, in these horrible weeks in particular, that is the crime of starvation that applies in the situation of Gaza. And if you know, there is a warrant of arrest that has been issued by the International Criminal Court last November on the 21st for the Prime Minister of Israel, Benjamin Netanyahu, and the former Minister of Defense, Gallant, that includes also the war crime of starvation. In particular, the warrant of arrest, sorry, I need to skip, I think I put it at the end. Oh, yes, this one. So you see there is a warrant of arrest that includes, so here is a hyperlink. I hope you can still see if I click it on it. Do you see? Sorry, can you confirm?
No, it didn't go through, Chantal.
It didn't?
No. Under your screen share settings, you can either share specifically to the presentation or to your whole computer. So you'd have to change the screen share settings.
We see the slide though where you've pulled out a lot of text.
Can you see it now?
Perfect.
Okay, because I thought it was just easier to click on the press release by the International Criminal Court that refers to the situation in the state of Palestine, the warrant of arrest I was mentioning. And in this warrant of arrest issued last November, there is a part that is dedicated to the crime of starvation. And therefore, I just wanted to show you this part and read it, maybe if I manage to read it to you. So, here it is. The chamber found reasonable grounds to believe that Mr. Netanyahu and Mr. Gallant bear criminal responsibility for the war crime of starvation as a method of warfare. The chamber found that there are reasonable grounds to believe that the lack of food, water, electricity, and fuel, and specific medical supplies created conditions of life calculated to bring about the destruction of part of the civilian population of Gaza, which resulted in the death of civilians, including children, due to malnutrition and dehydration. On the basis of material presented by the prosecutor covering the period until 20 of May 2024, the chamber could not determine that all elements of the crime against humanity of extermination. Okay, this is about extermination. And then there is one other very relevant part, I believe, for what's happening at the moment, that is, in addition, by intentionally limiting or preventing medical supplies and medicine from getting into Gaza, in particular anesthetics and anesthesia machines, the two individuals are also responsible for inflicting great suffering by means of inhuman acts on persons in need of treatment. Doctors were forced to operate on wounded persons and carry out amputations, including on children, without anesthetics, and or were forced to use inadequate and unsafe means to sedate patients, causing these persons extreme pain and suffering. And this amounts to the crime against humanity of other inhuman acts. So, sorry, trying to go back to my presentation. If you you see it?
No, not yet.
There you go.
Yes. So I was mentioning the fact that in these in these warrants of arrest, the crime of starvation has been charged with regard to the leaders, to the two Prime Minister and Minister of Defense of the State of Israel. And in particular, this crime has been charged for them as co-perpetrators, meaning that they really took the important actus reus, the conduct, they put in place the elements of these crimes. But this is not the only way to attribute individual criminal responsibility in international criminal law, and specifically in the Rome Statute, under the Rome Statute of the International Criminal Court. So again, just making it really basic, very simple, there are different forms of participation according to what is provided for in Article 25.3 of the Rome Statute. And these are commission, instigation, ordering, assistance, contribution to a group crime, or also incitement to genocide and attempt. But there is also Article 28 of the Rome Statute, and this is what I would like to focus in the remaining literally 5 minutes at disposal I have, that is called command responsibility. Why is command responsibility important? Because it's a mode of liability that makes the superior, the military commander, but also the civilian superior, responsible for the crimes committed by their subordinates, not for something that they did, not for ordering, not for participating in the crime, not even for instigating or planning them, but for something that they failed to do, a failure to act. So superiors are responsible for the crimes committed by their subordinates, also if they violated their duties to control, to prevent, and to punish. And these duties are directly imposed by international humanitarian law in the first place with regard to the war crimes that we are talking about. So why is this mode of liability so important for the topic of today? First of all, it is really embedded in the military structures. It is one of the original creations of international criminal law that comes directly from international humanitarian law. It is rooted in the hierarchical organizational structure that is typically to be found in the context of commission of war crimes, meaning during armed conflicts, during these broad contexts of war. And it is a useful mode of liability that has been used in the past, not so much until now by the ICC, but as I mentioned, we have seen it now in the warrant of arrest for Netanyahu, and we have also seen it used in the warrant of arrest for Putin, so the highest leader of the Russian of the Russian Federation, for the crimes committed by the soldiers, by the subordinates, even when there is no evidence of any contribution in terms of action by these leaders to the commission of the crimes on the part of their subordinates. So this doctrine is a very ancient one in military fields. Even some scholars trace it back to this Chinese military manual that was 500 years before Christ. So a very ancient, the Sun Tzu, famous Sun Tzu Chinese military manual, which was already talking about the responsibility of the commander when the troops are insubordinate. It was saying it's the fault of the commander, but also during the Second World War, in the aftermath of the Second World War, there was a very famous case that had to do with this liability regarding the General Yamashita, that was a Japanese imperial army general that was convicted for the crimes of his troops during the Filipino, in particular, part of the war. And after the Yamashita trial, we got the first codifications at the international level, and the most important one is to be found in Article 86.2 of Additional Protocol 1 to the Geneva Conventions of 1977. This provision already contained the principle that when there is a breach of the conventions or of the protocol that is committed by a subordinate, this does not absolve the superior for penal or disciplinary responsibility if the superior knew or had information which should have enabled the superior to conclude in the circumstances at the time that the subordinate was going to commit or was committing such a breach and did not take all feasible measures to prevent or repress the breach. So what you can notice is that at the time in 1977, the Geneva Convention, the additional protocol, was not clearly talking about criminal liability. It was penal or administrative. And it's only with the ad hoc tribunals then we have a clear criminal responsibility for this mode of liability, for this failure to control and failure to take the necessary and reasonable measures to prevent such crimes committed by the subordinates on, and therefore implying the superiors or the commander's responsibility. But it is only with the ICC statute that we have a full-fledged definition of this mode of liability that is also clearly now attaching also to the civilian leaders. Again, I skip the long definition that you will find in Article 28, but I just want to mention the three elements of this responsibility. Of course, there must be a superior-subordinate relationship. Also, there must be an element at the subjective element, which is that the superior must know or should have known, so negligently failed to know that the subordinate was about or had committed a crime, and this important conduct, which is the failure to take the necessary and reasonable measures to prevent the commission of these crimes by the subordinate. So here you will find in the slides some more details about these three elements, which I skip for now. And to conclude, again, I would like to mention the part of the arrest warrant for Benjamin Netanyahu and for the defense minister of Israel, Gallant, that involve this mode of liability. So in the press release that was issued by the ICC, the pretrial chamber on the 21st of November of last year, it is said that with regard to the crimes, the chamber found reasonable grounds to believe that Mr. Netanyahu, the Prime Minister of Israel at the time of the relevant conduct, and Mr. Gallant, Minister of Defense of Israel at the time of the alleged conduct, each bear criminal responsibility for the following crimes as co-perpetrators for committing the acts jointly with others, the war crime of starvation as a method of warfare, and the crimes against humanity of murder, persecution, and other inhuman acts. And then the judges add, the The chamber also found reasonable grounds to believe that Mr. Netanyahu and Mr. Gallant each bear criminal responsibility as civilian superiors for the war crime of intentionally directing an attack against the civilian population. So you see, specifically with regard to the intentional directing of attacks against the civilian population, there is this recourse to Article 28, which means that the two suspects are found to be responsible as civilian superiors for not having taken the necessary and reasonable measures in order to prevent or punish specifically this crime of attacking intentionally the civilians. Am I back in the screen? I hope I stopped the sharing. And I also, yes, and I also would like to stop here. And I, of course, remain at disposal later in case there are questions or clarifications needed. Thank you so much for your attention. I hope I didn't take too much time. Thank you.
Thank you very, very much, Chantal, for trying to guide us through the web of the criminalization of violations of the law of armed conflict and the development of capacities internationally and domestically to prosecute those crimes, and and achieve accountability for perpetrators of violations. Thank you very much. And now I would like to introduce Katherine Gallagher as our next speaker. And Katherine, of course, is going to talk about, she's going to engage in an analysis of Israel's violation of these complex laws of armed conflict in Palestine. Katherine?
Thank you, Gail, and thank you to the People's Academy for inviting me today to be with you and to join this stellar lineup of professors that you've had. I am a practitioner rather than a professor, so what I'm going to try and do in the time that I have is to take the concepts and framework that has been set out so ably in the first two presentations and give that some concrete effect by looking at the case study of Palestine. So I will be looking at all of the crimes that have been committed and are being committed across the occupied Palestinian territory by various actors. And while Israel is the occupying force, it is not the only one that bears responsibility for violations of international law in this context. So what I will seek to do is give a very brief applicable legal framework, the context that we look at and analyze crimes that are committed in Palestine or against Palestinians, an overview of some of the representative crimes, and a bit on enforcement. And here I will be looking to supplement, I hope, rather than repeat what has already been said and shared with you today. And while I'm talking about the situation in Palestine, I want to emphasize that a lot of what I am saying could be applied in other circumstances, and I think is particularly relevant. There are so many parallels to the situation of Ukraine and the crimes that are being committed there, particularly because of the occupation of Crimea and the occupation of the eastern Donbass area. So there are more parallels in law than we may see when it comes to practice of the way some states engage with the crimes being committed against Palestinians and against the Ukrainian populations. So just to begin in terms of the context there is an ongoing international armed conflict on the territory of Palestine and has been. And what I'm focusing here when I say international armed conflict, it is in that area of Palestine that we call the occupied Palestinian territories. Those parts of Palestine that have now been occupied for going into 58 years, arising out of the 1967 war. So we are talking about the West Bank, including East Jerusalem, as well as the Gaza Strip. And it is actually not, 2 points are not contested by anyone maybe than one of the parties to this conflict. And that is that all of the territory that I mentioned, the West Bank, including East Jerusalem, as well as the Gaza Strip, are occupied as a matter of international law. This has been reaffirmed again and again by the United Nations Security Council, most recently in a more explicit way in Security Council Resolution 2334 in 2016, though that is far from the only or even the latest Security Council resolution to recognize the occupation of the entirety of those territories that I mentioned. The General Assembly, again, has repeatedly recognized the West Bank, including East Jerusalem, as occupied, as well as the Gaza Strip. And the reason I'm emphasizing this is Israel has said that when it disengaged from Gaza in 2005, it no longer is in a position of occupation. And I think what the last 19 months in particular have shown, but frankly, the prior 17, 18, 19 years also demonstrated, as Gaza was under a situation of blockade and closure, is that Israel always had effective control over the ports of entry and exit from Gaza, the freedom of movement of the Palestinian population, control over the territorial sea borders and airspace, and these are some of the indicators of occupation under international law. And East Jerusalem, Israel has declared and tried to extend its law to East Jerusalem in 1980, and the Security Council said that that does not change the legal status of Jerusalem, East Jerusalem, as occupied territory. And of course, there have also been a number of UN bodies, including commissions of inquiry, fact-finding missions, UN special procedures that all recognize the status of occupation. And the second thing I would say is not contested as a matter of law is that occupation is a form of international armed conflict. And so regardless of what might be also happening alongside the occupation, with crimes being committed on the territory of Israel, for example, that does not change the status of the situation of Palestine being one of international armed conflict, and that therefore the full weight of international armed conflict, IHL, international humanitarian law, applying, and the full scope and scale of the laws of occupation applying. We've also had the International Court of Justice recognize the fact that these territories are occupied, and I will mention later on in a bit more detail the very, very important decision that came out from the ICJ, the International Court of Justice, in July 2024, when it issued an extensive advisory opinion on the legality, or as it concluded, the illegality of Israel's continued presence in the occupied Palestinian territory. So to come up with the conclusion that Israel's continued presence in that territory is unlawful. It had as a precondition to find that these territories, Gaza, West Bank, East Jerusalem, are in fact occupied. And as I mentioned at the start, when I said that we're not just going to be looking at Israel's legal obligations under international law. These ICJ decisions, Security Council resolutions, and what we can determine to be customary international law because of the consensus. This is binding, therefore, on all states parties, to all states, not just states parties. There are some obligations that flow to the signatories of the Geneva Conventions or the Genocide Convention, and then there are other obligations that exist for all states because of the nature of the way international law works. So once we are in a situation of a armed conflict, and again, in this case, I would say it's an international armed conflict to the extent that that distinction still matters, and I appreciate what Chantal said, that we shouldn't overemphasize this distinction at this point in time. But what that means that we're in an armed conflict is that the Geneva Conventions apply, the Hague regulations apply, and the Rome Statute for the International Criminal Court, Article 8, laying out war crimes. These all apply. And the reason when we're talking about Palestine that last instrument applies is because the state of Palestine is a member of the International Criminal Court. It joined the court in 2014, giving jurisdiction, it joined, on the 1st of January 2015, giving jurisdiction back to June 2014. And a member state of the ICC gives jurisdiction over two things to the ICC, the International Criminal Court, over its territory and over its nationals. So if a crime is committed on the territory of the state of Palestine, the International Criminal Court has jurisdiction. And that territory, going back to what I just laid out, is the West Bank, including East Jerusalem, as well as the Gaza Strip. And nationals would be nationals of the state of Palestine. So that means if a Palestinian commits a crime on the territory of another state, including Israel, that person can be brought before the ICC, even though Israel is not a member state of the ICC. One last point that I'm not sure was said in the first two presentations, but the implications, again, for other states when there is a situation of armed conflict as signatories to the Geneva Conventions and the Genocide Convention for that matter, is that per Article 1 of those treaties, those conventions, states that are a signatory to the conventions have an obligation not only to respect the provisions of the Geneva Conventions or the Genocide Convention, but also to ensure respect. So that obligation means to ensure that no other state is violating the protections laid out in the Geneva Conventions or the Genocide Convention. When it comes to the Genocide Convention, that has been understood to be a duty to prevent the commission of genocide, not just an after the fact obligation, but a obligation to take all measures that a state can take once they are on notice of a serious risk of genocide being committed. And likewise for the Geneva Conventions, ensuring respect means that when you are on notice that there is a violation of the Geneva Conventions as a a signatory, which pretty much means all states, you have an obligation to make sure that the offending state ceases that violation. So the protections for the Palestinian population, and I'll be honest, giving this presentation at this moment with the situation that we see in Gaza, it feels a little bit surreal to be laying out these protections when we see them in such gross violation on a day-to-day, month-to-month, and now year-to-year basis. But all states are obligated then to do what they can to stop these violations. Now, we're in this module talking about violations of international humanitarian law or the law of armed conflict. And of course, the Hague Regulations and Geneva Conventions are the backbone of IHL. But in the context of armed conflict, we don't only have the commission of war crimes, we also can have other crimes committed here. And these include two key categories of crimes. The first is crimes against humanity. So crimes against humanity also came out of the post-World War II era, the Nuremberg era, and the recognition that there are some crimes that are so egregious that they concern all of us and are really crimes not just against the victims, but against humanity. And the innovation of, or one of the key steps of the Yugoslav and Rwandan tribunals that was codified then in the Rome Statute for the International Criminal Court is to recognize that crimes against humanity can apply in times of armed conflict as well as in times of peace. So just for this audience, again, I know we're talking about the situation of armed conflict, but it's important to recognize that crimes against humanity can also be a tool in the toolbox of accountability in times not of armed conflict. But here, talking about the situation in Palestine, I will get into some of the specific crimes against humanity that could be applicable and why this is an additional, or should be an additional, protection to the Palestinian population. So what are crimes against humanity? They are a series of underlying acts that are committed on a widespread or systematic basis directed against a civilian population. So it's either because of the number of crimes that are being committed, the number of victims that are being created because of this criminal conduct, or the systematic nature, meaning you're seeing the same thing happen neighborhood after neighborhood, or detention center after detention center. You're seeing that there's something systematic in the way that the criminal conduct is being committed. And what you then also see, and what is codified in the Rome Statute for the International Criminal Court, is that there is a course of conduct pursuant to a state or an organizational policy. Now, this doesn't mean that you have to have written down a policy, but it could be one that is announced or one that can be inferred from, again, seeing that course of conduct in neighborhood after neighborhood or detention center after detention center. And a couple of the examples of crimes against humanity are murder and extermination, and also forcible transfer or deportation. And in the context of occupation, that can also be a war crime, and that could be moving a population out of their occupied territory or moving the population of the occupying force into a territory. We'll talk a little bit more as we go down the list of actual crimes being committed in Palestine onto crimes against humanity. But I think that this is particularly important because unlike the law of occupation and the law of armed conflict, which applies to the West Bank, East Jerusalem, and Gaza, the crimes against humanity can extend to crimes committed against all Palestinians. So that could be Palestinians inside the Green Line in Israel who are being discriminated against in a widespread or systematic way because they are Palestinians, and that is the crime against humanity of persecution, or it could be the crime against humanity of apartheid. And this could also be Palestinians who are in the diaspora, Palestinians who, because they are Palestinians, are not allowed to cross a checkpoint or a crossing to get in to the West Bank, to fly into Tel Aviv, to get to see family in Jerusalem. So I think that this crime against humanity overlay with other provisions of international law that are specific to armed conflict are particularly appropriate to think about in the context of Palestine. And then, of course, the other very, very serious crime that also can occur during times of peace or times of war is the crime of genocide. And so what we saw, for example, in the former Yugoslavia tribunal, there were many cases that dealt with crimes against humanity and war crimes, and those carry some very serious and long sentences. So I don't want to diminish the seriousness of the commission of war crimes or crimes against humanity. But what we also saw the ICTY, the Yugoslav Tribunal, find is that when it came to the enclave of Srebrenica, that specific area wasn't only a crime against humanity. It wasn't only a war crime, but when the Bosnian Serbs surrounded the Bosnian Muslim population, separated the boys and men from the women, children, and elderly, bussed the women and children out, and then put the men on a forced march where they killed 8,000 Bosnian men and boys over the period of a week in July 1995. They didn't say this is simply forcible transfer or murder. They said that this is genocide, because that conduct was seeking to destroy in whole or in part a specific population, the Bosnian Muslim population, in that eastern part of Bosnia, and it was done with the intent to destroy. And that intent in that case was inferred by the conduct of the Bosnian Serbs. As we'll talk about with the situation currently in Gaza, we have far more overt admissions of what the plan is for the Palestinian population. But I mentioned Srebrenica both because I think it's a chapter of history that is getting forgotten, and it is also a very powerful precedent to look at. The men and boys deserved protection, even though they were men and boys of military age, even though some of them may have had weapons as weak in contrast to the Bosnian Serbs as they were. The War Crimes Tribunal found that they still deserved the protections of international law. They deserved to be protected from the commission of war crimes, crimes against humanity, and genocide, be that targeted for destruction or otherwise not treated in accordance with the means and methods of approved warfare. So the idea that a population as a whole, or even a segment of the population, like the male population between the ages of, 12 and 80, can be targeted is something that we have very clear jurisprudence that international law is supposed to protect them from. I will move a little bit more quickly, but I also want to note that there is one other crime that we haven't really discussed here today that's also in the Rome Statute, and that is the crime of aggression. And the crime of aggression certainly is relevant to a discussion of armed conflict. The crime of aggression, known during the Nuremberg trials as the crime against peace, this was at that point seen as the crime of crimes. This is a violation of the UN Charter, where armed force of one state is used against the sovereignty or territorial integrity of another state. It can be through invasion or attempts at annexation. So there are different challenges at this point in time of actually enforcing the prohibition on aggression. It is something that, because of Russia's actions in Ukraine and particularly around Crimea, there has been a fair amount of focus in the last few years about really increasing enforcement and potentially even building a separate tribunal to deal with this crime. But I think it's also one that is very, very relevant to the discussion of Palestine. Okay, so with that background and just maybe a footnote to everything I've said as I look at my notes, Palestine has had non-member observer state status at the UN since November 2012. So that was a precursor to joining the ICC as a member state, and it's also something that's relevant to take into account when thinking about the crime of aggression. So some of the representative crimes that we're seeing committed at this moment, literally, in the occupied Palestinian territory, we're going to go through those. And I'm going to do something that is not I tried to think how not to do this, because when I'm going to talk about Gaza on the one hand and the West Bank and East Jerusalem on the other. And I want to just acknowledge that in so doing, I am in ways replicating the very fragmentation of the Palestinian territory and people that is part of, I think, the plan for Palestine and erasing Palestine. I'm going to do this more divided analysis when it comes to war crimes and genocide, even more than crimes against humanity, because I do think that that's a place where one can put a more holistic analysis on the crimes being committed in Palestine. And even again, as I do this division between Gaza and the West Bank, I also want to emphasize that what we're seeing is that what happens in Gaza often migrates to the West Bank and Jerusalem. So I'm laying it out in this way in part because of the factual reality at the moment, and in part because of the way it enables or assists in seeing the analysis of crimes. But again, a disclaimer that this is in no way intended to reinforce the fragmentation or division of a unified Palestinian territory or state of Palestine. And likewise, a disclaimer at the start, as I look at Gaza in particular, the criminal conduct did not begin in Gaza after the October 7th attacks. There had been a closure on Gaza in place since soon after Hamas was elected. So there was about a 17-year closure by the time October 7th happened. And this means a denial of a range of rights to Palestinians in the Gaza Strip, 2.1 million people or 2.2 million people. We don't have exact numbers. Who were denied access to freedom of movement, freedom of education, freedom of family unification, really a crime against humanity of persecution over the course of that blockade, that Israel, again, was exercising effective control over entry, exit, and the territorial space of Gaza. And over the course of the decade or so prior, there had also been a number of military assaults on Gaza. I remember back in late 2008, early 2009, with so-called Operation Cast Lead, the world was shocked to see a military offensive against a closed Gaza Strip that led to many, many civilians being killed. And again, at that point, even a high percentage of children being killed. That led to the Goldstone Commission, a fact-finding mission, and calls for accountability, calls for an end to the occupation, calls for an end at minimum to the blockade. None of that happened. And so we saw in summer 2014 a 51-day military offensive named Operation Protective Edge, where again, civilians were killed in very large numbers across the Gaza Strip. Civilians who should have all of the protections of IHL that we heard laid out by the first two panelists today, the first two faculty today, and that didn't happen, nor did the accountability happen. So there were precursors building up to what we saw happen today. And of course, there was the attack on the Great March of Return, a non-violent, peaceful call for resistance and return in the Gaza Strip, where protesters instead were shot and killed. And that led to yet another UN Commission of Inquiry. So the crimes have not started, did not begin on October 8th, but we are in a moment of just unprecedented cruelty and harm across the entire Gaza Strip. So what we've seen since October 2023, at least 53,000 people have been killed, of whom at least 16,000 are children, 8,300 are women. It is estimated that 1,400 healthcare workers have been killed and at least 213 journalists. One of the things that I think we all have to remember with these numbers is that there are so many people who remain buried under the rubble. There are a lot of people who it's not known if they're in detention in an Israeli prison or if they are dead. So these numbers are estimates. They're shocking, but they are most certainly not as high as they ultimately will be. 120,000 people have been wounded. Literally millions have been subjected to forced evacuations, where the population was told from the north to move south, from the south to move north, move down to Rafah, move over to Khan Yunis. So repeated internal displacements of most of the population of Gaza, with many people now reporting 6, 7, 8 times being forcibly transferred within the Gaza Strip. The civilian destruction is widespread of schools, homes, religious institutions, bakeries, which provide needed food, infrastructure destroyed. The list goes on. The part that I think is most notable to reference is 40% of hospitals have been destroyed, with the remaining left partially functioning. It's worth anyone who's listening to this and interested in more of the facts to seek out some of the testimonies and interviews given by doctors who got into Gaza and worked alongside extremely brave Palestinian medical professionals. They are among the few who've been able to go in and out, and that's been increasingly difficult, but have been able to bear witness and share information about what they saw. So with these numbers that I've given you, which reflect human beings and their homes and their lives and their histories, we have a number of war crimes that have been committed. Let me just... So beginning with willful killing, which is a grave breach of the Geneva Conventions. And as our two professors told us, grave breaches are really the highest level of crimes, meaning that they should have the highest level of enforcement to prevent them and punish them when they occur. They trigger universal jurisdiction. We've also seen torture. And whether it's the prisoners who we saw stripped and blindfolded and with their hands tied up in Gaza, or the many who are disappeared and then families eventually find out that their loved one was detained in an Israeli prison. The number of people in detention who are being tortured is at a very, very high level. And here I would point to Palestinian organizations like Adamir, which are doing incredible work under very difficult conditions, or the Palestinian Center for Human Rights, which just put out a devastating report last week on torture. Other crimes, and that is a grave breach. And here, doctors are not immune from being detained and tortured. And Dr. Abu Safia is a case in point. That this is someone who many of us came to know from his interviews with Western media, and then now he is detained and in increasingly grave danger. We've also had willfully causing great suffering or injury to body or health, another grave breach, widespread. I gave the number of 120,000 who are injured. The willfully causing great suffering or injury, this also includes mental harm. And the statistics out of UNICEF on the situation for children in Gaza is devastating. I would also highlight the incredible and painful work done by Defense for Children International Palestine in continuing to tell the story and the lives of Palestinian children who are killed and injured, and the mental impact that what has been going on over these many months, which we all can see, is having on the next generation. Other war crimes include extensive destruction of property not justified by military necessity and carried out unlawfully and wantonly. This is one where we hear a lot, and especially in the early weeks, we're hearing a lot about military necessity and really looking at, was this building, was there a target, a military target in it, or in that one? I think it's important to go back to what our first professor told us about military necessity. That analysis needs to be done before a strike, and it needs to be done in accordance with the practices that are recognized under IHL. And if one were to look through the jurisprudence of the Yugoslav War Crimes Tribunal and look at how military necessity was assessed there compared to what we are hearing it should be assessed in this context, there's no resemblance. There's very little resemblance, because the idea of military necessity has been able to swallow up the prohibition. And I would suggest that rather than looking at an incident by incident basis, one has to look across the entirety of the Gaza Strip, where you are seeing time and time and time and time and time again that the use of a 2-ton bomb, a 2,000-pound bomb, a bunker-busting bomb, drone helicopters that are strafing entire refugee displaced tent camps, and seeing that the results are the death of children in such high numbers who are clearly not participating in hostilities in any way as children. They are protected persons of the highest order, journalists, the same, doctors and medical professionals, the same. There's something very off in the analysis of these kinds of killings are somehow deemed to be justifiable. Other grave breaches of war crimes, and again, I'll move more quickly through this, include unlawful transfer and deportation. I mentioned about the continual forced evacuations and displacements. And of course, now there are also not homes to go back to. 92% of the housing units have been destroyed or damaged. OCHA, UN Office of Humanitarian Affairs, is an excellent resource that continually puts out updates on statistics on everything from access to drinking water to access to food supplies to number of schools or places of worship that have been destroyed. So that's where I'm taking these statistics from. And again, it's 92% of housing units destroyed or damaged, with more than 1.1 million people in need of emergency shelter. Hostage taking is also a grave breach. And I think just to supplement to what Chantal said about the ICC arrest warrants, not only were arrest warrants sought and granted for Prime Minister Netanyahu and former Minister of Defense Gallant, but they were also sought for 3 senior Hamas officials. 2 of them were killed, assassinated, before the arrest warrants could be ruled on. And then the third case, even when it was issued, but that person is also killed. So there were arrest warrants sought that included the taking of hostages on October 7th, but none of those cases at this point, at least the ones that we know arrest warrants were sought, will make it to trial because all of the would-be defendants were killed. But I think we also need to think about the taking of hostages in the broader sense, and this could also be those who were captured in Gaza and taken to detention centers in Israel without charge, again, not knowing who or where they were taken. Chantal spoke about intentionally using starvation of civilians as a method of warfare. This is one of the war crimes that is part of the arrest warrant that was issued already in November. Now, since the issuance of that arrest warrant, we went through a period where there was a brief ceasefire, and that ceasefire was breached. And then we were in a period of 11 weeks again of complete blockade where no food got in. And the warnings out of the United Nations over these last 11 weeks have been as dire as they can be. And today, for the first time, it was applauded that 9 trucks got in. Now, thankfully, 9 trucks got in, but that is not what you need when you have a population where UN has found that literally 100% of the population face high levels of acute food insecurity. Over 1 million people face emergency levels of food insecurity, and 470,000 people are facing catastrophic levels of food insecurity. So 470,000 Palestinians in Gaza at this moment are seeking are in a state of food insecurity, despite there being arrest warrants for this war crime of intentionally using starvation. There are a number of other war crimes that are relevant to take into account. Particularly, I would highlight intentionally directing attacks against buildings dedicated to religion, education, art, science, hospitals, etc. At this point, 2,300 education facilities from kindergartens to universities have been destroyed or damaged, including 57 university buildings. Approximately 80% of Gaza's mosques have been destroyed, including the 1,400-year-old Great Omari Mosque, and 3 churches, including the 3rd oldest church in the world, have been destroyed. So these are war crimes. This is conduct that has been put in the Geneva Conventions that should not be happening. I would just recall that the purpose of these laws of armed conflict, what I call the international humanitarian law, it is to be protective. It is not to give green lights for all kinds of conduct in war. Rather, it's supposed to curtail and contain the means and methods of war to protect civilian populations. And what we are seeing in Gaza is that more often in the political discourse, it's being weaponized to justify and excuse attacks on civilian population, civilian infrastructure, and frankly, the entire population. Again, I will move very quickly. I know that my time is coming up. I want to touch on the West Bank, including East Jerusalem, for war crimes that are being committed there. What we've seen is a very, very serious uptick in what was already a very, very difficult and bad, increasingly bad situation across the West Bank and East Jerusalem. Here, the biggest trends that we're seeing is killings, home demolitions, mass arrests, and settler violence. So before you have settler violence, you have the movement of settlers into the occupied territory. And so that is a violation, again, of the Geneva Conventions of transfer of your population into the occupier's population into an occupied territory. And we've seen Palestinians transferred out, refused reentry, having their documents rendered invalid. We've also seen pillage of natural resources, and pillage is a war crime. I will touch briefly on crimes against humanity. Again, what I said earlier about crimes against humanity, in part because they can apply in times of armed conflict and in times of peace, and also because of what are recognized as crimes against humanity. I think that this is a particularly useful lens for taking a more holistic view of the crimes being committed across the Palestinian territory, the occupied Palestinian territory, and against Palestinians, whether those in Palestine or those in the diaspora. When we are looking at Gaza, we have the crime against humanity of murder, the crime against humanity of forcible transfer, and I'm just mentioning a couple, and the crime against humanity of extermination. Extermination includes the intentional infliction of conditions of life, and this includes deprivation of access to food, medicine, that is calculated to bring about the destruction of part of a population. So what I detailed above, we have the food insecurity situation in Gaza, and this is not a coincidence. This is not a result of a humanitarian disaster. This is the result of a promise made by senior Israeli officials in the days right after the October 7th attacks to impose a total siege on Gaza, where it was said no food, no fuel, no electricity, no water. So this was the creation of conditions of life that we have seen that declaration, that promise carried out over these 19 months as humanitarian assistance, as first of all, Palestinians being denied the ability to grow food themselves, to feed themselves, to be self-sufficient. But then after creating these conditions where there is continual bombardment, forced movement, displacement, and terror, what we're seeing is that the humanitarian assistance is being denied. 90% of households are experiencing water insecurity, and this is in part because of what the infrastructure that was bombed early on in this military assault, so that access to clean drinking water is not a given. And nearly a million children, as I mentioned, are in need of mental health and psychosocial support. When it comes to the West Bank, deportation and forcible transfer, again, out and in are two of the key features that we see. Imprisonment, the widespread use of administrative detention, where Palestinians are detained without charge on suspicion, held for months at a time, renewable months at a time without charges, which can turn into years at a time. So the situation of Palestinian prisoners and Palestinian political prisoners is again at record high numbers. And alongside that, we are seeing an uptick in torture. And then another crime against humanity that I think is relevant to the West Bank, to Gaza, and to all areas of historic Palestine is the crime of apartheid. And this is where you're imposing two different legal regimes, two different sets of laws and protections based on who someone is. And that is a crime against humanity that is very much related to another crime against humanity of persecution, which is the denial of fundamental rights to a group because of who they are. So it's a discrimination-based crime, and those fundamental rights could be the right to movement, education, life, freedom from torture, family reunification, practice of your religion. So things that have been recognized across the human rights regime can be underlying acts of persecution. And then some of these crimes that I've mentioned as crimes against humanity ultimately build into the crime of genocide when you have the intent. So genocide is the intent to destroy in whole or in part a population based on maybe nationality, religion, ethnicity, race, destroy that population as such. So it's not simply that you have a large number of casualties or victims out of a population, but it's that they are being targeted for destruction as such. And if you look at the underlying acts of crimes against humanity, of extermination and murder, those are two of the underlying acts of genocide. So killing is an underlying act, as is creating conditions of life to destroy a group in whole or in part. So the line between where something is extermination and where it turns to genocide really turns on intent. And again, we've had those. So now we come to we'll come to enforcement, and I'm just looking at the chat, and I'll be tying this up in 5 minutes so that we can have discussion. So looking at enforcement, I'll hit two sides: against whom and where. So based on the framework that's been laid out, the first level, and it not necessarily in a hierarchy, but the first where maybe you could have the most protection if there were actual enforcement is against states. States have the duty to respect and ensure respect for the Geneva Conventions, the Genocide Convention. And as I said, when it comes to genocide, there is an explicit recognition of the obligation, the duty to prevent genocide. So that is something that has been in place since those genocidal statements were made back in October 2023. And if not then, at least since the International Court of Justice ruled in January 2024, which states, certainly Israel as a frontline state, which is committing directly these violations against the Palestinian population. I would add the United States, whether the line for the US at this point is as complicit or whether it's as also committing. I think there could be a question because the United States has continued to send weapons for use in Gaza month after month. And as experts have put in declarations in court proceedings, but for the US weapon supply, which is billions and billions of dollars that have been sent since October 7th, billions and billions of dollars before October 7th, and the opening of a $4 billion arms stockpile in Israel for its use after October 7th. what we're seeing in genocide could not happen but for US military support. And it's not just military support, it's also political and diplomatic support. But it's not only the US and Israel. As I said, all states have responsibilities, and third states, especially when it comes to provision of arms to Israel, need to take those responsibilities seriously. So you have state responsibility, as we talked about with the ICC. There is also individual responsibility. A place where that could happen is certainly the ICC, but it could also happen in national courts, be it civil or criminal, and that could be for direct liability, complicity, or as Chantal laid out, command responsibility. So I think we could be looking at the Israeli political and military leadership, US political leadership, dual citizens. And this is an area where we are seeing some investigations. Those citizens of the United States, of France, of Belgium, of South Africa, of most countries, frankly, in the world, who have gone and fought as part of the Israeli forces in Gaza, including after the ICJ ruled that there is a plausible genocide, or in the West Bank to enforce a occupation that the International Court of Justice has also declared illegal. So we are starting to see some more dual citizen cases. And then the settlers. The settlement enterprise in and of itself is unlawful, but there has been, over the last at least 10 years, and the last few years especially, a real uptick in settler violence. And this doesn't happen in most cases without the tacit, if not overt, support of Israeli forces backing up settler violence against Palestinians. So we have states, we have individuals, we also have companies. And that could be the arms manufacturers who have been on notice that to continue to provide weapons is complicity in genocide, furthering war crimes, and furthering crimes against humanity. Also, the tech companies, there has been reporting of tech companies using AI to assist Israel in some of its targeting in Gaza under programs like Lavender or Where's Daddy. This is a very, very concerning trend. And then those enforcing the siege of Gaza. What we're hearing in recent days about the possibility of US contractors giving selective access to food in Gaza. Of course, we all want humanitarian supplies into Gaza. Of course, we all want the Palestinians in Gaza to have food and water, but to have it controlled by US companies for profit under a regime where it is still contributing to either war crimes or crimes against humanity, I think is deeply problematic. And then in the West Bank, we've seen companies maintaining and profiting from the illegality of the occupation and pillage. And there I would really urge listeners to look to El-Haq, the Palestinian organization based out of Ramallah, which for a long time has been doing excellent reporting on the profiteering, who's profiting from the occupation. So where do we go? We talked about the ICC. The arrest warrants are out there. The United States has been putting tremendous political pressure on the ICC. There is currently an executive order by Donald Trump that threatens sanctions on the court itself, but so far the only person who's been designated, and I say only in quotes, is the prosecutor of the ICC himself, Karim Khan. So that has led to some states, maybe some within the courts, being very concerned about the Palestine investigation proceeding for fear that somehow it could undermine international law if there is allowed to be accountability for Palestinians. I would encourage instead states and those within the court to say no. If the United States and Israel and others are allowed to say no justice for Palestinians at the ICC, it's the international legal order itself that is the victim here. We also have the International Court of Justice, which has been active. There's the South Africa the Israel case that led to the finding, the first set of provisional measures in January 2024, finding that there was a plausible genocide. That case continues. There was also a case, Nicaragua v. Germany. This turns on that respect and ensuring respect obligation under the Geneva and Genocide Conventions. And this is about the provision of arms and other support for the commission of war crimes. So that decision is out there, and then the advisory opinion. So I think we have places where we have seen enforcement. We will continue to see enforcement and should see far more at the national level, including under universal jurisdiction laws, but there is still not the kind of enforcement to give real protections that this body of law was set up to do. I'm sorry I went so long. I'll stop.
Thank you very much, Katherine Gallagher, for giving a presentation that was illuminating, exceedingly distressing, but offered a ray of hope with regard to attempts at enforcement. I know that Chantal Meloni has to leave in a few minutes, so could I suggest that the three presenters start your discussion amongst each other with the issue of enforcement, and maybe Chantal, because you have to leave, you could be the one to start. Thank you very much.
Yes, well, thank you very much, Gail. I was listening carefully to Katie, and yes, as you said already, it was growing this sense of also frustration, very honestly, because being lawyers, as we are dealing with this situation for many years, and at the same time now reading what exactly is happening today, it's so, how do you say, distressing. But I don't really have a question. I have maybe, yes, another point out there, which is at the level of enforcement. I think that Katie was touching the most important points, which is at this point, what are the consequences? And maybe, maybe this is a question for Ali as well. What are the consequences for states at this point, all states that have failed to prevent this genocide, to punish it, to stop Israel from committing it? In a way, you know, what I was talking about a bit quickly, I realize in terms of command responsibility, this mode of liability that is embedded in international humanitarian law, and then went into international criminal law as a tool to prevent in particularly the atrocities, the violations of international humanitarian law, because there is this component as well. It's not only about the punishment. And then, of course, if it's not possible to prevent, there is also a liability, and it can also be criminal responsibility for having failed to punish what was not possible to prevent or what has not been prevented. So I'm now thinking loud, but of course there is a level of, again, of responsibility of the individuals, but there is a level of responsibility of the states. And I don't know, and I would like to hear from the others what they think. My impression in these months is that the ICJ, as well as proven, the International Court of Justice, the highest UN judicial body, of course, has proven to be very weak vis-a-vis this situation, and also the attempt done by Nicaragua, bringing Germany as a state, right, with the responsibilities towards of course, the genocide convention, not to provide weapons to its ally Israel, has proven to be incredibly weak. So yes, maybe I would like to raise this issue, and then I already say I'm sorry, but I will need to leave because here in Berlin, where I am, is late, and I need to go to my daughter.
Ali, Thank you, Chantal. Did you want to comment on the?
Yes, thank you very much, Chantal and Katie. Very, very good and strong and moving presentations. With regard to enforcement, my question would be the question I sometimes raise in classes with students. Do you trust international law to enforce? And very early on, I tell them that my answer would be no. What is international law? It's an order created and strictly controlled by the victors of World War II. How? Through the United Nations and its organs, especially the Security Council, where the victors of World War II have absolute and ultimate control over what will happen and what will not happen. In these circumstances, you have the victors of World War II, the United States, its allies in Western Europe, Russia, China, creating a global order, the master's order, that I believe needs to be brought down. But international law is not a tool that will break down and bring down and dismantle this unjust order, because international law is a tool created by them to preserve the order. Chantal mentioned that the International Court of Justice has been very weak. And I would say, yes, absolutely. But not just with regard to what has been happening in Palestine over the past couple of years. Let's rewind back a little bit. And Katie mentioned genocide in Bosnia. What was the outcome of the hearing in the ICJ in the Bosnia versus Serbia case? The International Court of Justice said, nah, that's not genocide. Genocide needs strict conditions, and these are strict conditions. And I don't believe that Serbia, the state of Serbia, was involved. I don't believe that Serbia was helping the Bosnian Serbs to the extent that creates liability for the state of Serbia. In the same manner, do you think that the same judges of the same court cannot potentially get up and say there is no liability for Germany, there is no liability for the United States of America, there is no liability for other allies of the terrorist state of Israel, because the support that they gave is not sufficient in strength and is not sufficient to meet the requirements for them being implicated in genocide? Let's look at also the case brought by the Gambia against Myanmar in 2022, I believe. Genocide in Myanmar is ongoing. It took Gambia, a tiny country in the west coast of Africa, to take Myanmar to court. Nobody else was interested in doing so. The evidence is pretty much there. It's been 3 years. What has the court done in this 3-year period? So if the court is going to deal with genocide in Palestine and elsewhere, we look at the court's actions in similar genocide cases so far, and the court does not show, unfortunately, and this is my view, others might be opposed to this view, the court does not show that it has been taking the matter seriously, even in situations where the court has acted according to the international law created by the victors of World War II to deal with aggression. Nicaragua versus United States in 1984. The United States decided not to participate in proceedings. The court ruled in favor of Nicaragua anyway. The United States refused to comply with the judgment. And in circumstances where a state refuses to comply with judgments, what happens? The court notifies the Security Council for the Security Council to take action up to and including action under Chapter 7. But a very young John Bolton back then was saying, what is Nicaragua going to do? they're going to take the case to the Security Council. Big deal. We own the Security Council. And that is exactly what happened. The United States uses its veto in the Security Council to effectively stop the judgment of the court from being carried out. In these circumstances, I have very little trust in a legal system that is a tool created by the owners of the global system to fairly deal with such issues.
Wow. Thank you, Ali. Katie, would you like to respond briefly? We're at 11:45 now, so Pacific time, that is, so that we have a few minutes for, there's many questions from the people attending also.
Sure. I don't disagree with anything that Ali has just said. I don't disagree with any of it. I think what's notable is that despite this infrastructure being built by the powerful to protect the powerful, what we've still had is arrest warrants for Benjamin Netanyahu and Yoav Gallant. What we've still had is 3 sets of provisional measures out of the ICJ in the South Africa case, and kudos to South Africa and the states that are now joining that proceeding to back it up and to back up the obligations to protect the Palestinian population in Gaza from genocide. What we've seen these institutions take some pretty unprecedented action. And I would say that the Gambia v. Myanmar case is another example where we've seen the ICJ stepping out of its more staid role in the international legal order to actually engage in a process that might protect in real time human beings, and put some of this legal framework into effect. So I guess I'm not sure that I would put as much criticism on the international institutions themselves, because actually they're working. You can look at every commission of inquiry that's come out, or the special procedures, be it the working groups or the special rapporteurs. We are papered to the ceiling with condemnation and outcry and pleas of the highest order from Palestinians on the ground in Gaza, from Palestinian human rights organizations, being echoed directly in UN documents for a change of behavior. And we're not seeing it. So I don't know whether the fault is the institutions per se, is I think, Ali, more what you were laying out, or even the legal framework. I think what the issue is the political will. And I think what ultimately I really agree with you is that the structure was built by some for some. And what they don't like is when populations that they didn't envision as having rights and obligations to protect human rights for others, when they come into the crosshairs of this legal structure. But I don't think we can end just by saying we don't like it. I think we have to continue to try and use it and to keep pressuring. When the Palestine situation was opened at the ICC, I don't think anyone believed that there would actually be arrest warrants for Bibi Netanyahu. Or at least that it would be in the time period it's in. Now, it's come because of the absolute horror that we've all watched happen and continue to happen as we're speaking here for 19 months in Gaza. It's happened at such a high cost of life. So I guess if we do need to continue, in my opinion, to use these international institutions to try and effect change and bring more into the fold who are saying, if this is the system that we've created, we either have to enforce it or we throw it out. I'm pretty scared of where we're going to go if we throw out this system, but we need to buttress all of that and complement all of that by action outside the courts. And whether that is action on the streets, protests that we have not been seeing in the numbers that we need to. I mean, again, kudos to those in The Hague with 100,000 people out over this last weekend. We need to be seeing that everywhere, all the time. We need to be seeing more demands made of our governments to actually enforce principles of human rights and humanitarian law. And then we need, as consumers, to say, if this is who you're supporting and backing up, we are not supporting you. So I think that I guess while I share all the critique, I also maybe I just don't have the imagination to be able to see what else we could be doing, you know, by abandoning that field. I'm not willing to abandon it. I'm willing to continue to try and force it to be used against those who always thought they were above it. But to give that whatever wins we get in the formal sense, to have that backed up outside with voices, with presence, with people power to try and get some effect.
Katie, spoken like a true battling lawyer. Thank you. Can I give you two questions, just jumping off from there, to answer that come from the people that are attending? First of all, the issue of complicity, particularly of lawmakers and executives in the US and other countries who vote and allocate funds they know will go to commit genocide and crimes against humanity. And the second question that is similar: what can be done domestically and internationally by individuals to hold accountable the individuals in states who are refusing, either by statements or actions, to comply with the International Criminal Court arrest warrants against Netanyahu and Gallant? Who wants to start?
I can start if you wish. Or with regard to the first question, we have a concept in international law, a principle of compelling law or peremptory norms, or in Latin, the jus cogens. These are the most fundamental and the most basic of all rules that cannot be violated under any circumstance whatsoever. An example of these peremptory norms is genocide. Another one is no aggression, no torture, no slavery, crimes against humanity. So if officials in state A, B, and C are funding or any other way supporting crimes against humanity in state D or E or F, then they cannot claim immunity. Immunity is automatically waived because these peremptory norms, these fundamental laws, cannot be violated under any circumstance, under any justification whatsoever. So the current order allows for action to be taken, but the institutional structure is not there. So in theory, we have something that can work against government officials in Germany, government officials here in Britain, where I am, in the United States, etc., etc. But in practice, the institutional framework is not there.
Katie?
Yeah, I'll just add on to that briefly. One of the things that we didn't talk about from the Rome Statute, the ICC statute that came into effect in 1998, and then the court came into being in 2002, is that placed an obligation on all 123, 24, the number varies, member states of the International Criminal Court to domesticate all of the legal framework in the ICC. So that means if you haven't yet put a genocide criminal statute, you have to. If you haven't yet put the grave breaches of the Geneva Conventions as war crimes in your domestic criminal codes, you have to. And same for crimes against humanity. So I agree completely. We have a legal framework and a legal infrastructure now, not only at the international level, but at the national level, where all of this conduct is clearly prohibited. And it's clearly prohibited not only for those who commit jointly, but also those who aid and abet, which means knowingly providing practical assistance that has a substantial effect on the commission of the crime. And that can take many forms. Again, the key there is knowledge. When we come to a situation like Ukraine or like Myanmar, the crimes against the Rohingya, and certainly the crimes against Palestinians, that knowledge is there because of UN commissions of inquiry and frankly because of the news. These are notorious crimes being committed in notorious ways because of senses of impunity. So I do think we need to see the war crimes offices that have been set up as a result of this new legal infrastructure at the national level, having more pressure put on them to hold not only Syrians who should be held accountable if they've committed crimes, or Rwandans out of the Rwandan genocide, or members of the Taliban accountable, but also to hold Israeli officials, US officials, and their own. We do see a number of cases right now that are playing out in countries that give me a little bit of hope. That's in the UK, in Canada, in Belgium, in the Netherlands, where there have been efforts to review the provision of arms to Israel. And so that's looking at more of a state responsibility level. There were hearings last week over 4 days in the UK, which has stopped sending many weapons to Israel, but continues, as do other countries, to send component parts for an F-35 to the United States, effectively recognizing the United States as a money launderer for weapons components. So they can say we're not selling directly to Israel, but then they sell and provide weapon parts to the US, which go on and make their way to Israel. So we need to see the kind of public pressure that brought those cases in those countries that have changed behavior. And I would submit, giving a little bit of credit to the ICJ, that the fact that there are provisional measures of a plausible genocide, as well as that decision in the Nicaragua v. Germany case, as well as the ICJ's advisory opinion on the illegality of the occupation, that has changed some countries' behaviors. Not enough, and not somewhere like the United States. We tried to hold Joe Biden accountable in the United States. I was part of the legal team in Defense for Children International Palestine versus Biden, Blinken, and Austin. And in that case, Ali, you just talked about how there should not be any immunity for these crimes. We were charging them with failure in their duty to prevent genocide and complicity in genocide. And they said that, look, even if we say that recognize that this is a violation, the court, our own domestic court, can't hold us accountable because of the political question doctrine. They essentially said that whatever the executive deems to be appropriate foreign policy, that can't be reviewed by a court. And this was the Biden administration. I mean, under the Trump administration, we're going to see that kind of argument again and again and again. And it's dangerous. It essentially says that there is someone, a king, above the rule of law, that some are not to be held to account. And I think we've seen this watering down of the international legal system since after September 11th and the US global torture program, where people were able to get away with it. People were able to get away with setting up black sites and CIA secret detention sites and torturing countless people in Afghanistan, Iraq, and in black sites in Eastern Europe, because they said it was in the name of quote unquote national security. So we do have a certain reckoning that we have never dealt with as to the belief that national security and power trumps law. But I don't think that means we can't continue to try through courts, but also through political processes. Unfortunately, what we saw in the United States out of US complicity in the Gaza genocide was Jamal Bowman and Cori Bush out. Those are two members of Congress who called for a ceasefire and called for an end of support for genocide. And instead of being reelected, they were ousted in Democratic primaries. So we have a lot of work to do outside the courts to change the calculus for members of Congress to those who are asking. It should not be that you're ousted for trying to uphold the rule of law, but rather reelected and ultimately in greater positions of power.
Thank you, Katie. We do indeed have a lot of work to do. I'm very sorry we didn't get to any more questions. We'll try and figure out a way to answer those questions. I just want to say briefly, thank you to our three wonderful presenters for sharing their extensive knowledge of the provisions, violations, failure, and use of this important, very, very important area of international law. I also want to say thank you very much to the people attending this People's Academy course. Lawyers, students, activists, human rights defenders, academics, concerned people from more than 90 countries have attended our courses and seminars. The faculty teaching our courses and seminars that we've had so far practice and work in Africa, Asia, Europe, North America, and South America. So we are trying to put together a big group here. International law, as we heard today, relies on people knowing the law, insisting on implementation and adherence, and using the law to impose accountability for perpetrators of violations and redress for victims. And that is important work that we have to do. The next program for the People's Academy of International Law will take place on Thursday, June the 12th, the International Criminal Court and Prospects for Justice and Accountability. Faculty will include Triestino Marianello and Beth Lyons and others. Again, thank you, everybody. Obviously, all the topics touched on by Katie, Ali, and Chantal today need to be the subject of another course. Thank you for attending.